Today, I will be speaking to you about Processo per stupro, a trial for rape, translating yesterday's rape trial discourse for today. My co-author is Claire Kennedy from Griffith University, and I am Luciana D'Arcangeli. In May 1978, a collective of Italian feminists filmed the trial of 4 men in Latina, near Rome: Rocco Vallone, Cesare Novelli, Roberto Palombo, and Claudio Vagnoni, which culminated in their conviction for raping an 18-year-old woman known as Fiorella, as her family name was not disclosed. The resulting observational documentary, Processo per stupro, A Trial for Rape, 1979, was intended by its 6 makers to bring the public face to face with the reality of rape trials, showing how a victim of rape underwent a second violation in court, being effectively transformed from complainant into defendant. Produced for the Italian state television broadcaster Rai 2, it was viewed by millions and generated vast public discussion as intended. Francesca De Ruggeri in 2009 pointed out that it was the first time television cameras entered an Italian court, not to turn a trial into entertainment, but as a political tool. Although described by Mili Buonanno as one of the most iconic programs in the history of Italian television, the multi-award-winning documentary has disappeared from Rai TV programming and is not available commercially. Public calls to rescreen it in 2019 to mark its 40th anniversary were to no avail. Commentators surmise that the censorship is aimed at protecting the professional reputations of the defense barristers and their heirs, and you will see why later on. At the same time, Renato Chiocca, a writer and director based in Latina, the city where the trial was held, inspired by the powerful words captured in the documentary, decided to give A Trial for Rape a new life in the theatre. He selected and adapted passages from the transcript and directed and produced performances of the resulting eponymous play in Rome, Latina, and Cagliari in 2018. This paper was born from the will to make this play available both to Italian speakers. Its text, together with others, was made available in our 2021 book titled Atti di accusa, testi teatrali e interviste sulla rappresentazione della violenza contro le donne, and to English speakers with our forthcoming book, Staging Violence Against Women and Girls, Plays and Interviews. Claire Kennedy, who translated the text, and I, who due to time constraints ended up mainly acting as editor, are now working on adapting the translation into English subtitles to make the recording of the play also available to a wider audience, and that effort will probably end up in another paper. Here we want to discuss the dilemmas we faced during translating and editing, where we felt we had to explain items that might puzzle readers and provide some further reflections regarding the language of the trial. Neither Claire or I are legal translators, so we relied on A.K. Bromley's 1992 article on Italy's 1988 New Code of Criminal Procedure and research by Dr. Loiacono of Curtin University, as well as Luisa Conte's professional help. In translating, we envisaged our audiences as likely to be broadly familiar with legal judicial procedures in English-speaking countries belonging to the common law tradition, which is significantly different from the civil law system of Italy and those of most other countries of continental Western Europe, and especially from the form it had in 1978, prior to the aforementioned changes. Furthermore, much of the academic research that we have found published in English on the language of rape trials and discourse analysis of trials relates to the common law systems, so we hope to be of service to a wider audience. In our introduction, we have already referred to legal representatives as barristers, although the Italian term avvocato does not correspond exactly to barrister. The distinction that applies in Australia, for example, between a barrister, representative in court, and a solicitor, intermediary between client and barrister, does not exist in Italy, where an avvocato performs the functions of both. So this was to be the very first point of interest. When the barristers are addressed in court, the form of address is usually avvocato, referring to their role and their usual title outside court as well. And we simply used counsel or my colleagues as they did not use any embellishments. To further complicate things, we refer to Fiorella as complainant, but, strictly speaking, at the trial, she was not just the complainant. Having applied for and been awarded the status of parte civile, that is to say, she was an aggrieved party in criminal proceedings, she was to be represented in court by a barrister. This barrister's role is independent of that of the pubblico ministero, literally public ministry, or in translation, the prosecutor. That is the set of public offices that represents the state in criminal proceedings. Lo Iacono explains this as being one of the radical differences in categories and concepts between the civil law tradition of continental Western Europe and the common law culture inherited from England. In Italy, the barrister acting for a parte civile can examine witnesses and defendants, engage in plea bargaining and negotiation of damages, and most significantly, deliver arringhe, oral submissions on behalf of the aggrieved party, to the court during a trial. These speeches can make or sum up a case and rebut the defense submissions. This situation provided a forum for Tina Lagostena Bassi's famous speeches and contrast with that described by Susan Ehrlich as limited advocacy and lack of agency for complainants in common law countries who appear only as witnesses for the state and are not directly represented by legal counsel. An important development in judicial practice that is foreshadowed in the A Trial for Rape was that of allowing an organization to be constituted as additional parte civile in a criminal trial, representative collective interests that are damaged by the crime, something else we have found the need to explain. Two organizations, the Feminist Movement of Latina and Women's Liberation Movement of Rome, applied unsuccessfully to appear as co-complainants with Fiorella. Again, we simplified the term in favor of immediacy and comprehensibility. In the court, there was no jury, but a panel of 3 judges, chaired by the presidente, or the presiding judge, and 2 giudici a latere, or assisting judges. Thankfully, in the play script, the contribution of these are all assigned to the presiding judge, and we refer to him simply as the judge, and use Your Honor when others address him with Signor Presidente, Mr. President. Similarly, questions were put to the defendants and witnesses only by the judges, including those questions raised by the barristers, so this was easily dealt with. Some elements that are foreign to English-speaking readers' expectations are influenced or determined by elements of the Italian procedural code. So, for example, we considered it useful to explain that the defense barrister's oratory is so little concerned with evidence, partly because of the way their role in a trial was construed in and constrained by the procedural code, and also that it is standard practice to have an unmediated confronto, literally discussion, that entails the simultaneous questioning of 2 people, each of whom may be a witness, defendant, or parte civile, whose accounts of any important facts or circumstances given under questioning differs. The latter is exactly the case between the complainant Fiorella and the main defendant Vallone, and the judge inviting them to confirm their statements and or contest each other's declarations, and that features both in court and in the play. Rachel Fenton, in her 2010 research, Rape in Italian Law, Towards the Recognition of Sexual Autonomy, notes that the fact of having rape cases decided by a panel of professional judges rather than a jury may be an advantage of the Italian system, especially with regard to mistake of fact evidence regarding perception of consent, because the defendant would have to be fully credible and any suggested mistake would have to stand up to judicial scrutiny. The other principal area of concern for us in terms of accuracy of translation was that of words used for the acts under consideration at the trial. As Coates et al. Put it, language affects events and creates versions of reality. And creating versions of reality is exactly what the participants in any trial are engaged in. The work of these scholars in analyzing the language of rape trials, and in particular the ideological work of words used to describe violence, led us to reflect further on the language of the various speakers. We reviewed and edited the translation in light of certain insights of theirs on fitting words to deeds. In particular, the choices of words for the defendant's acts for accuracy at a discourse level and focusing on language that mutualizes violent behavior, as we found that to be prevalent and arguably more insidious in the text than the use of eroticizing terms and euphemisms, which are also present. Eroticizing language is particularly characteristic of the defense barristers' arringhe, or oral submissions, and absolutely blatant. One example will suffice to render the idea, and it is that of the defense barrister Zeppieri. So, Vallone begins with an act of cunnilingus, a long, mellow, evocative, penetrating cunnilingus. The sexual activity among this group of people does not begin with a slap. It begins with the most penetrating act of love of a man for a woman. However, in this analysis, we're more interested in the questioning sequences where the discursive construction is more subtle. We found that the words used by the judges, defendants, and defendants' barristers to describe the men's acts at the villa tended to be words rewriting rape as sex, to borrow words used by Duncanson and Henderson in their 2014 research titled Narrative, Theatre, and the Disruptive Potential of Jury Directions in Rape Trials, when describing the foundations of rape myths. The expression most frequently used in relevant questions to the defendants and Fiorella was rapporti carnali, for which various bilingual dictionaries give sexual relations, or just rapporti, relations. It was also used in the official report on the case read out at the start of the trial. We chose intercourse, or sexual relations, in the translation because these are terms to describe sex in formal language, and both imply interaction, a joint activity. An example is this question to Fiorella regarding the events at the villa. And who was the first one you had intercourse with? The same expression was sometimes used by the defendants in their responses. In some questions, the judge used coito, which, while apparently more technical, is translated in dictionaries with sexual intercourse, as well as coitus, and tends to be described as a sexual act and a joint one, in keeping with its Latin origin, coire, meaning to go with. At one point, the presiding judge used the verb congiungersi. And was Vallone still there while you coupled with this girl? Which may have been an attempt at more formal or technical language, but it is still a term for a joint act. The prefix con indicates with, and the dictionaries give the meaning as couple with or copulate with. In many of these cases, it would have been difficult for the speaker to find terms or short expressions that serve the purpose without using words usually applied to sex between people. In Italian, as in English, as noted by Coates and et al., a solution might be found by spelling out a graphic and more wordy description of an act. There are many more examples, of course, but I would like to address the language used by Fiorella and Tina Lagostena Bassi to refer to the deeds, as it is in marked contrast to that of the men. We do not actually see much questioning of Fiorella, but in what we do see, her language does not speak of sex. For example, when she recounts, after they had raped me, we went back into the living room. I mean, they made me follow them. She is speaking of acts against her will, acts of force. She has to answer a couple of questions that include the word rapporto, rapporti, but she doesn't use that word in her answers. Her counsel, Tina Lagostena Bassi's careful attention to the choice of words for deeds is evident throughout the text and reflects concern to distinguish not only between rape and sexual activity, but also between rape as violence in itself, violation of a person's autonomy, and violence accompanying rape. Her care appears intended to counter the defense barrister's consistent representation of violence only in terms of that which is used or threatened in order to overcome a victim's resistance. One of the most revealing utterances in the text, in terms of the manifestation of rape myths, comes from the otherwise rather objective judge. Just prior to beginning his questioning of Fiorella, he notes her nervousness and says, smiling benevolently, Do you need moral support? There's no need. As you can see, you're not alone. You're here. We're all family men. So there's no need to look to your adoptive mother. Not only does he appear unaware of the irony in this literally patronizing statement, given that we know that at least 2 of the men Fiorella has accused of group rape are husbands and fathers, but he thus declares his own adherence to a very significant myth about rape, that women are not at risk from married men. Indeed, they are protected by them. A myth that perhaps Fiorella too had subscribed to, as Tina Lagostena Bassi brings to the fore near the end of her closing statement. Fiorella's experiences at the villa and in court involve a manipulation of trust. This is not a matter of one person's word against another's. What we have here is a matter of taking advantage of a girl's good faith. She went along with Vallone trustingly because she knew him, because until then she'd only had normal relations with him, nothing sexual, because she knew Vallone was married, because in her eyes he was an older man, not someone to think of in that way, a man with a wife. Finally, in expressing a wish for change in future, she again uses just the word violenza or violence to refer to rape, not violenza sessuale or violenza carnale, that is sexual violence. Perché queste violenze siano sempre meno, perché le donne che hanno il coraggio di rivolgersi alla giustizia siano sempre di più. So that there will be less and less of this violence, so that more and more women will have the courage to go to the law. For us, a lesson from the above reflections is that even 40 years ago, and in a social cultural context that defined rape as a crime against morality and public decency, it was possible to attend to language in a rape trial to fit words to deeds in a way that countered the male perspective that established the norms. At least, it was possible for those who understood its significance. As for progress in the trial experience in Italy, among the very few studies available compared with those conducted in English-speaking countries, Chiara Federica Pedace's 2017 article, Da vittima a imputata, la violenza sessuale nel procedimento penale, which analyzes a small number of trials, found that the judges' questioning tended to perpetuate stereotypes of sexual relations that see men as naturally aggressive and women as responsible for protecting their own bodies, and indeed blameworthy if they cannot. The reasons that in Italy as elsewhere, rape is still a drastically underreported crime becomes clear, and there is significant attrition at each stage on the path from disclosure to others, to reporting to authorities, to prosecution, to conviction. Responding to these issues, Italy in 2019 enacted the so-called Codice Rosso law, which translates as both Red Code or Code Red, updating the penal code, the procedural code, and provisions for protection of survivors of domestic and gender-based violence. It mandates the activation of specific training courses for police and prison officers. The Italian magistrate Paola Di Nicola, known for her commitment to countering prejudice in the judiciary, when interviewed on the effectiveness of the changes 1 year later, stated, and I quote, "It is important to stress that the real site of the fight against gender violence is not the courtroom, although this does not mean that it should not be a place in which women can find trust and support. The serious and worrying problem is that the social structure around the response to violence against women, which is composed largely of police, witnesses, lawyers, and magistrates, is a substratum that is still characterized by ingrained prejudices and stereotypes whose existence cannot be denied." Close quote. Reforming the ways criminal justice systems treat survivors of sexual violence is not only important to survivors, it also signals to society how sexual violence should be viewed. It is an essential part of the fight for the elimination of violence against women, which needs to be fought on many levels: sociological, educational, and medical, as well as judicial, and to be understood as aimed at benefiting the whole of society, because the personal and societal costs are high. As rape tends not to be seen as a major public health issue, despite the ongoing mental and physical health problems faced by survivors and the economic cost to them and society, the European Institute for Gender Equality has issued a report in 2021 that estimates gender-based violence costs for the whole of Europe. For Italy, these amount to almost 39 billion euros per year. Progress is slow, and the issues needed to be tackled on multiple fronts. The Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, which is in force in Italy and many other countries, recognizes the importance of education to achieve cultural change and training of relevant professionals under the first of its 4 pillars, prevention. The potential of the arts in this area has been highlighted by many. In the case of our theatre director, Renato Chiocca's decision to adapt A Trial for Rape reflected his conviction of the power of the theatre to allow us to perceive reality in different ways. As he said, and I quote, "The theatre can provide a separate terrain from which to interpret the law from an emotional perspective," end of quote. On viewing the documentary for the first time, Chiocca had the idea of creating his play, feeling that the words spoken at the trial nearly 40 years earlier were still of great significance. He explained in an interview, and I quote, "Although Italian law moved forward in 1996, thanks to the women's rights struggles, I think perhaps that public opinion, the media, and the conduct of the defense in many trials for rape remain stuck in the past. And it seems to me that Italians might need to hear these words again." The task of bringing about lasting cultural change, as advocated by Tina Lagostena Bassi in 1978, remains pressing. We hope that by publishing, translating, facilitating staging, publicizing, and analyzing the now play A Trial for Rape, we can contribute to this goal because, as Renato Chiocca said, on stage 40 years later, those words still thundered with their importance and immediacy. Grazie.